The European Union's General Data Protection Regulation, GDPR, comes into force on 25th of May 2018. What does your organisation need to do to comply with the new law? In this session, we discuss contracts and contractual issues relevant to GDPR. A crucial first step towards GDPR compliance is to identify your organisation's role in relation to personal data. You may be a controller, you may be a joint controller, or you could be a processor or sub-processor. While controllers have the main duties and obligations under GDPR, processors also have new and specific obligations, including an obligation to assist and support data controllers' compliance procedures. A data controller may only use processors who provide sufficient guarantees in relation to technical and organisational measures to ensure that processing is GDPR compliant. Processing must be governed by a contract, meeting at least the minimum requirements set out in GDPR Article 28(3). Those terms are designed to ensure that processing meets all the requirements of GDPR, and not just those related to keeping personal data secure. Data processing contracts must set out the subject matter and duration of processing, the nature and purpose of the processing, the type of personal data and categories of data subject, and the obligations and rights of the controller. Contracts must include a minimum set of terms, mandated by Article 28(3). They include provisions requiring the processor to act only on the controller's written instructions. Provisions to ensure that personnel or contractors involved in processing the data are subject to a duty of confidentiality. Provisions requiring the processor to take appropriate measures to ensure the security of processing, and obligations only to engage sub-processors with the prior consent of the controller and under a written contract. The minimum terms mandated by Article 28(3) also reflect the processor's obligation to cooperate and to assist the controller to meet its own compliance obligations. Specifically, the processor must be contractually obliged to assist the controller in meeting data subject access requests, and to assist the controller to meet its obligations in relation to data integrity and security. Article 28(3) also reflects the processor's role in relation to the controller's duty to meet the data minimization principle. The controller must ensure that personal data is processed only to the extent and for so long as required for the purpose specified by the controller, and only for so long as there is a lawful basis for processing. That could be consent or contractual performance, or perhaps legitimate interests of the controller. To support the controller's obligations, the processor must be required by contract to delete or return all personal data to the controller as requested at the end of the contract. The processor must also agree to submit to audits and inspections, and to provide the controller with information to meet the accountability principle, which is a pervasive aspect of GDPR. In addition to the mandatory Article 28(3) clauses, guidance from the regulator, the Information Commissioner's Office, also recommends that contracts should state that nothing within the contract relieves the processor of its own direct responsibility and liabilities under GDPR, and reflect any indemnities that have been agreed. The Information Commissioner's Office assumption that indemnities might be agreed perhaps reflects the possibility that data subjects might choose to proceed against either the controller or processor for compensation following a data breach. Indemnity clauses might provide a way for a party who pays full compensation under Article 82 to recover not only the share of compensation attributable to the other party, but also incidental costs such as investigation or legal fees incurred in responding to the claim. Indemnities might also perhaps seek to cover elements of fines or regulatory penalties, though the effectiveness of such indemnities may be open to challenge as a matter of public policy. The Article 28.3 minimum requirements apply to all data processing contracts in operation on 25th of May 2018, when GDPR comes into force. New contracts can and should include GDPR-compliant clauses from the outset. Existing contracts, the term of which extend beyond 25th of May 2018, may require variation to add or update data processing clauses. Variation may be effected by formal agreement, or in some cases by correspondence and conduct that shows intention to be bound by the revised terms. Where contract variations are required, seek advice on the precise steps to be taken to ensure valid variation. Controllers may only use data processors with whom they have a binding contract, meeting the requirements of Article 28 of the GDPR. Similarly, if a data processor wishes to engage a sub-processor, there must be a contract that imposes on the sub-processor the same obligations as those governing the controller-processor relationship. Data processors must remember, though, that if a sub-processor fails to fulfill its data protection obligations, the initial processor remains fully liable to the controller for performance of the sub-processor's obligations. GDPR Article 26 provides that where two or more controllers jointly determine the purpose and means of processing, they are regarded as joint data controllers. Where parties are found to be joint data controllers, they must determine and document their respective responsibilities in an arrangement. That arrangement could be a contract, or it could be something less formal, such as a memorandum of understanding or a data sharing protocol. Whatever its form, the essence of the arrangement must be made available to data subjects. Data subjects may exercise their rights against each controller, perhaps inducing data subjects to take action against the closest, deepest pockets. Recovery, for example through indemnity provisions, could therefore depend on the clarity with which joint controllers have set out their respective obligations and duties in the arrangement that they have documented. The ICO Data Sharing Code of Practice indicates key elements of any arrangement between joint controllers that should be documented. They include statements restricting the use of personal data to specified purposes, statements identifying and specifying the basis on which processing is lawfully carried out. There should be statements that reflect the specific GDPR obligations undertaken by each controller, for example for security measures, record keeping, appointing data protection officers, or responding to breach. Clarity in the allocation of responsibilities could, in practice, prove to be the key to effective recovery of an appropriate share of any liability following a breach, for example through Article 82 of the GDPR or through a contractual indemnity. Given the significantly increased penalties and sanctions under GDPR as compared to previous data protection law, controllers must review and update data sharing agreements or protocols to meet GDPR requirements. If you have any queries or would like to seek advice on any of the issues discussed in this webcast, please contact our data law team. Contact details are on your screen at the moment. Thank you for listening to this webcast. Please join us for our other sessions on data controllers, data processors, data protection officers, data privacy impact assessments, and responding to personal breaches.